Thanks everyone for joining us for today's webinar, FDA's pre-market review process, what's the latest? My name is Kyra Hill, and I'm joined by my colleague, Neil Sircar, and we're both staff attorneys at the Public Health Law Center located at Mitchell-Hamline School of Law in St. Paul, Minnesota. We both work on our center's FDA project, which closely monitors the federal regulation of tobacco products. So we're here to talk to you today about the FDA's pre-market review process and then provide some more information about latest developments, which I'm sure you're all eager to learn about. For those of you who aren't familiar with the Public Health Law Center, we're part of the Law and Policy Partnership to End the Commercial Tobacco Epidemic, which is a joint initiative of the American Lung Association and the Public Health Law Center. And our goal is to support tobacco control professionals in their work to end the commercial tobacco epidemic in California. Next slide, please. I also want to acknowledge that the Public Health Law Center is located at the Mitchell-Hamline School of Law in St. Paul, Minnesota. We acknowledge that we're in the indigenous homelands of the Dakota people, also known as the Sioux Nation, and that 4 federally recognized Dakota tribal nations remain in the area. The region is also shared territory with the Anishinaabe, also known as the Ojibwe or Chippewa, and the Ho-Chunk Nation also has a historic relationship to the region. We appreciate the ongoing stewardship, spiritual connections, and lifeways developed in these homelands upon which the law school sits. Relatedly, I also want to acknowledge that throughout this presentation, we'll be referring to the regulation of tobacco, but I want to clarify that I'm talking specifically about commercial tobacco. I'm not talking about traditional tobacco, as it is still used religiously, medicinally, and ceremoniously in many different cultures. At the Public Health Law Center, our goal is policy that improves the public health. This means taking into account the social determinants of health, adverse childhood experiences, and inequities in general. We consider it our responsibility to use our legal knowledge to bring justice to public health as we support our partners in reducing health disparities. When all people are healthier, the communities they live in are happier, safer, more vibrant places. At the Public Health Law Center, we provide partners across the country with legal technical assistance relating to commercial tobacco control, which includes conducting legal research, assisting with policy development, implementation, and defense, issuing publications, and conducting trainings like this one. We do not represent individuals, so if you need specific legal advice, please seek out the advice of an attorney licensed in your jurisdiction. We also do not lobby. So with that, let's go through what we're here to talk about today, which is the FDA's regulation of tobacco products, the past, present, and future. First, I'm going to talk a bit about how the FDA regulates tobacco products, including what it has and hasn't done. Then, Neil is going to lead us through the current landscape and specifically the pre-market review process that applies to products like e-cigarettes, which I know is probably top of everyone's mind now that we're seeing marketing orders and marketing order denials come out. Lastly, we're going to talk about what we can expect from the FDA moving forward, particularly as it pertains to e-cigarettes. And then we'll conclude with a Q&A session. As Stephanie mentioned at the outset, please feel free to place questions in the Q&A throughout the webinar and we'll address them at the end. So the first question on everyone's mind is probably something like, what is pre-market review? Well, pre-market review is the process that applies to what are called new tobacco products under the Tobacco Control Act. And new tobacco products is specifically defined in that law as products that were commercially marketed after February 15th, 2007. Since all currently marketed e-cigarettes were not on the market before February 15th, 2007, that means that all e-cigarettes must go through the pre-market review process in order to be commercially marketed in the US. This means that technically speaking, all e-cigarettes are supposed to receive affirmative marketing orders from the FDA before they can be sold in the United States. Obviously, that's not what happened, and we'll talk a little bit more about why that is in a bit. Before I delve into that though, I just want to review the legal standard that all cigarettes are supposed to meet before they can receive a marketing order from the FDA. We refer to this standard as the public health standard, and it articulates that generally speaking, the authorization of the product has to be, quote, appropriate for the protection of the public health. And this requires taking into account the risks and benefits to the population as a whole, the increased or decreased likelihood that existing users of tobacco products will stop using those products, which is also known as cessation, And lastly, the increased or decreased likelihood that those who do not use tobacco products will start using those products, aka initiation. The FDA doesn't have any further guideposts to work off of beyond these three prongs. So it has a lot of latitude to determine whether something is appropriate for the protection of the public health. So we now know that all cigarettes are supposed to receive marketing orders from the FDA, and that in order to be sold, and that in order to receive marketing orders, the agency has to determine that the sale of those products would be appropriate for the protection of the public health. It would meet the public health standard. So, as you well know, that's not what happened in reality. Rather, we saw the popularity of widely available e-cigarettes take off in 2017, driven largely by the popularity of JUUL. You can see the popularity depicted on this chart, which shows e-cigarette sales in blue, and then JUUL's large market share represented by the color red. To get a sense of how much of a role the FDA could have played in preventing what happened with the popularity of e-cigarettes, let's take a look at some significant events overlaid on the graph that we just looked at. So for example, the deeming rule, which gave the FDA authority to regulate things like e-cigarettes, took effect in August of 2016. Right after that point, the FDA could have required e-cigarettes to come off the market pending regulatory authorization, which is pretty much the outcome and the structure that the Tobacco Control Act envisions. But as we know, the FDA did not do that. And even as the use rates were skyrocketing, especially among youth, the FDA did not force products to come off the market. It had the authority to act, but it didn't. And, obviously, even absent any significant meaningful action on the part of the federal government, e-cigarette use has come down from its 2019 peak for both high school and middle school students, according to the National Youth Tobacco Survey. That said, COVID-19 threw a wrench in the ability of researchers to collect data for the NYTS. So we have to kind of take that into account. But even so, we know 11.3% of high school students reported past 30-day e-cigarette use, which is almost 2 million students. So that's almost 2 million students still reporting e-cigarette use during the pandemic, which is extremely concerning from a public health standpoint. And then according to a study published in the American Journal of Public Health, retail and social access limitations were significant factors in the decrease among e-cigarette users during the pandemic. And then I also want to note that the most popular products amongst youth are now Puff Bar and Vuse rather than JUUL, which underscores the fact that the regulatory approach from the FDA should be one that is preventative rather than reactive and piecemeal, which it has been historically speaking, because as many of you probably know, when the FDA ultimately did act to remove flavored pod and cartridge-based products from the market, the popularity of products like Puff Bar exploded. It's also really important to understand from the standpoint of FDA pre-market review that there are a few timelines that apply, and we need to talk about specifically the most important dates and how they came about. So you can see 3 timelines depicted on this slide. The first one was the timeline that was laid out in the initial deeming rule. That was in 2016 when the agency first got authority over products like e-cigarettes. The second timeline represents the proposed timeline that FDA articulated when it announced in 2017 that it was effectively going to be pushing out deadlines for applications by 5 years until 2022 and never ordering products to come off the market. It was ultimately that kind of complete failure to enforce the statutory requirements outlined in the Tobacco Control Act that led to a lawsuit by public health groups led by the American Academy of Pediatrics, or AAP. And that ultimately resulted in a judicial order that imposed that third timeline you see on this slide here. And that's the one that applies now. So it was that lawsuit that resulted in 2 deadlines that you've probably heard about. The first one is September 9th of 2020, and then September 9th of 2021. The first deadline in 2020 was the date by which manufacturers were supposed to submit applications for marketing their products to the FDA. The manufacturers that submitted their applications were then given basically a 1-year grace period during which they were allowed to continue marketing their products as the agency was reviewing their application. That 1-year grace period ended in September 9th of this year, 2021. And after that date, products without marketing orders were supposed to come off the market. So what actually happened by that date? Well, the FDA basically issued a press release saying it had made, quote, significant progress on the review of e-cigarettes and other deemed products, having taken some sort of action on over 90% of the applications that had been submitted. That said, having, quote, taken action doesn't necessarily mean final action. We're still awaiting decisions on the marketing applications of the biggest names like JUUL and others. And that 90% number is somewhat misleading because 4.5 million of the products, of the 6.7 million products that product applications that were received were from one company, one single company who did not actually comply with their requirements for filing applications in the first place. And then that company was issued a refuse to file or RTF letter. So among other things, that company had failed to comply with the requirement that companies submit what's called an environmental assessment of their products. So basically, the agency refused to take a substantive review of those specific applications in the first place. So with that, I'm going to turn things over to Neil to talk about kind of the present state of affairs with what's been going on with pre-market review.
Thank you, Kyra. And it's my pleasure to dive into this section of our webinar with all of you. For many of you, it's the first time meeting me. My name is Neil Sircar. I'm one of the new staff attorneys with the Public Health Law Center. And I'm very excited to share with you the update on the pre-market tobacco application review process. There has been a recent final rule that FDA put out, and that's what we're going to dive into here. So Kyra touched on a little bit of this already, so just to repeat some very good points there. As you can see, it's a fairly long process before a company can even receive an affirmative marketing order from the FDA. And even after a company receives that order, there are things that are expected of them, the post-approval reporting and such. The agency's evaluation includes such things as reviewing a tobacco product's components, its ingredients, additives, constituents, toxicological stuff, the health impact, which is an important part of when we're thinking about health equity and really trying to get to a point where we're not initiating new users to these products. Kyra touched on that a few moments ago. And as well as how the product is manufactured, its packaging, its labeling, really important when it comes to things like health claims, and findings from consumer perception research, also related to things like health claims. More than a few people sent in a few questions in advance of this webinar that kind of touching on that point specifically. So Kyra and I will circle back to that. The FDA did issue a rule, as I mentioned this year, that has some more of these details fleshed out and finalized. What are the requirements on manufacturers that they have to follow? And it includes some procedural changes, as well as some, not minor, but some changes to the way in which applications can be sent in. For example, the way in which a supplemental PMTA or an amendment to a PMTA might be submitted. So as Kyra noted a few moments ago, in order to market their products, manufacturers must demonstrate to the agency that, among other things, they are permitting the marketing of the new tobacco product would be appropriate for the protection of the public health. We keep circling back to this one phrase because it's an incredibly important phrase that is also somewhat nebulous. FDA also will use APPH at times as an acronym to stand in for it. So if you ever see that in any of their materials, that's what this is referring to, appropriate for the protection of public health. And it means using a public health standard or the public health standard to assess whether a product's marketing will indeed ultimately protect the public health. Again, because there aren't really clear guide rails, aren't really any kind of guidance there's no guidance in what this means, how it looks, on how the standard will be applied in each circumstance in which it would be applied. The companies themselves effectively get to determine which studies and what types of impacts and what kinds of risks and to whom are going to be analyzed on a broader scale. So we know that some of you are wondering what happens to all of the products that aren't supposed to be on the market right now. That's actually another question that a few people had sent to us. Because they're either awaiting a marketing order, a denial or granting, or they received a marketing denial order, an MDO, or they had never submitted an application in the first place. They're just on the shelves. So the main form of enforcement that the FDA has used to date has been to issue warning letters to manufacturers. We should note that the FDA does maintain a list on their website of the warning letters that they have sent to the manufacturers, saying who they sent them to and when, and you can access the letter in a PDF form. The list includes letters that are almost exclusively sent to e-liquid manufacturers, particularly the ones who have manufactured flavors and who never sent in a PMTA in the first place. Of the many products that FDA has to review through this process, the agency does have authority to issue civil monetary penalties as well. It can even seize products, but it has never done either of these things with respect to manufacturers of tobacco products, but they can. And since September 9th of this year, FDA's Center for Tobacco Products, the main part of the FDA that works on these issues, has issued 57 warning letters to companies that have their products being sold without authorization, primarily, again, products that are e-liquids. It's also worth noting from this highlighted portion that FDA is very clear that they are prioritizing manufacturers who did not submit a PMTA. So FDA has received over 6.7 million PMTAs, mostly from one company, but they have received over 6.7 million PMTAs. They've issued over 1 million marketing denial orders. As of today, they've also been sued by over 40 companies with respect to those PMTAs being rejected. We'll see what might come of that. A few of those decisions have been rescinded, some have been stayed. It's an ongoing process. We're all very excited to see what comes next. We certainly understand that FDA, as an agency with limited resources, needs to prioritize their efforts, and especially in light of some of the numbers here, and as all of us know, just the number of goods that are out on shelves. It is worth noting that pretty much all of this was foreseeable. A lot of it was avoidable to the extent that the heavy burden that is now on FDA didn't have to be concentrated in the way that it is. Had FDA decided to act sooner than they did, some of this could have been handled a bit more efficaciously. But here we are. So for those products that have gone through the PMTA process by submitting an application, the FDA needs to prepare an action. Marketing granted orders, the authorization for sale of a product, is what all of these companies want. A marketing denial order is not, and the FDA has broad authority to issue a denial order. The FDA stated in a recent press release, recent as in last February, that given the number of applications that they had received, that they didn't think that they would be able to review all of them by the September 9th, 2021 deadline, and they were correct. They did, however, get through a good chunk of them, as Kyra noted. The FDA managed to complete a filing review of over 90% of the PMTA submissions that were received, and the remaining applications are going to continue to be reviewed by the FDA, who will then make enforcement decisions at their discretion, again noting that their resources are limited and they cannot act against every unlawfully marketed product at once. Underscoring something that Kyra had said a few moments ago, these are unlawfully marketed products unless they have a marketing granted order at this point. Don't have the grace period anymore. This is the world that we live in, and the marketers and manufacturers, they know it too. So just to throw some numbers at everyone on the call, FDA has issued marketing denial orders to over 260 companies, and has issued marketing granted orders to 2 companies and 7 products. The 3 products from R.J. Reynolds, the Views products, and the 4 products from U.S. Smokeless Tobacco, the Verve products. To put that into a larger perspective, FDA has not yet issued authorization or denial to the single largest company, JUUL, as measured by their market share of e-cigarettes. That's a choice. It's an interesting choice. I defer to the FDA for why they made that choice. It's also worth noting too that you can see in that second large blue bar there that it says Views, and that's true, that 36% of the market share right now is held by Views, but Views is a family of products. Views Solo was the one product that R.J. Reynolds approved, along with the things that go with it. So we don't actually know if Views Solo is the predominant Views product within the family line of Views that people are using, or just one of several, and the rest of these are the ones that are being enjoyed by a number of people, including minors. So as of today, there are 7 new tobacco products that have received marketing authorization: Verve's Discs and Chews, which come in blue mint and green mint flavors, and Vue's vape pens, the Solos, which are sold in original and menthol flavors. Following the lead of local action in places such as San Francisco, Livermore, Richmond, and elsewhere across the great state of California, where I'm from and I love, multiple jurisdictions have passed ordinances prohibiting or limiting the sale of flavored tobacco products or e-cigarettes and e-liquids. Several of these jurisdictions have a qualifier that their prohibitions only apply to those products that do not have FDA marketing authorization. Flavor restrictions that include mint and menthol and do not have an exemption for products with FDA marketing authorization are not yet affected, though exemptions for flavors such as menthol and tobacco are fairly common. So what does marketing authorization from the FDA ultimately mean? Like what is that to the people on the ground? In a nutshell, companies that receive the marketing granted order may legally have their products on the shelves. They can sell them to retailers, they can sell them to consumers, barring any local restrictions that we're going to touch on in a moment. One important takeaway is to note that the FDA has authorized marketing because, as highlighted in this letter, that they determined that the products are appropriate for the protection of public health. Another important takeaway is that these marketing granted orders require the sale and marketing of the products to comport to certain requirements, these specific approved ones at least. And these requirements are primarily around age verification for the consumers and restrictions on certain forms of marketing or advertising that might bleed over to minors, now meaning anyone under the age of 21. So broadcasts and digital advertising that have an over 15% minor audience, for example, programs that are 99% for minor audiences or have a minor audience that is 99% of the total audience. Other requirements include labeling and naming sponsorship for influencers and brand ambassadors, and maintaining records on all advertising impressions. So what's next? What does this mean for what happens over the next 6 months of the review process? For those of you who were with us some months back, we highlighted how some communities were moving ahead without the FDA. California, as a state, has proposed a flavor restriction, which passed the state government, but has been placed on hold until November 2022 in the general election vote next year, owing to a successful referendum push from the tobacco industry and its allies. San Francisco, Livermore, Contra Costa, San Luis Obispo County and City, and Carson have all implemented language that prohibits the sale of unauthorized FDA products, and several of these cities, many others, have flavor restrictions as well. One step further, Beverly Hills and Manhattan Beach have famously prohibited the sale of all tobacco products with a few exceptions. Ordinances like those, which are referred to as endgame initiatives, are those that are designed to permanently change the structural, political, the social dynamics around sustaining containing and ending the commercial tobacco epidemic, ideally by 2035. So California's local ground game is the engine behind a lot of the country's tobacco control infrastructure. And that will need to continue as the regulatory framework is finalized and authorized products like Verve and Vue's begin to take hold in the market. A strategy emerged to defer to FDA authorization, as we noted earlier, and that was fairly successful, but here we are. We're starting to get products that are FDA authorized. And so far as that strategy has been challenged, either on the ballot or in court, public health and tobacco control the community has prevailed. While enjoying popular support, that particular deference has generally been very well received by voters and the general community alike. But here we are. We have these products, and we can expect over time to have more products trickling out. So the next step is to close some of these gaps and to really continue building that ground game towards something like an end game. Local authorities can, for instance, remove the prerequisite that FDA must authorize a product for it to be sold or distributed, or just have a straight prohibition. Have a clean smoke-free city or a clean smoke-free county or the like. What that will look like and how that would be received by elected officials and the public is going to be very contextual. You all know your communities a lot better than anyone else does, and I think you understand what I mean by that. Another step, and maybe an easier one to gain some initial traction on, is to close the flavor gaps. Jurisdictions that exempt certain flavors, like menthol, could remove those exemptions. Just treat all flavors as alike. Likewise, exemptions on certain tobacco products and flavored tobacco products, like hookah tobacco, could be removed from the ordinances. Just really make them as comprehensive as they can be. And coming up next, Kyra, what's the future lying in hold for us?
All right. So I do want to address something that keeps coming up in the chat, and I promise we'll get to all these questions. I know there's a lot of eager folks out there to talk about some of this, so we're really good amount of time for that. Another area of opportunity and really need that we need to address in the tobacco control community is to address next generation products that aim to circumvent FDA regulation, and most regulation built around tobacco-derived nicotine. So non-tobacco nicotine products or synthetic nicotine products are emerging on the market, and related studies show that these products are very popular with youth and young people. The FDA currently does not regulate these non-tobacco nicotine products under the same regulatory regime as tobacco-derived products. And though the FDA has sent warning letters to the most infamous company doing this, Puff Bar, and they're really the biggest brand in this new space, that really has not prevented young people from acquiring colorful, flavorful nicotine products because there's really been, to our knowledge, no follow-up efforts on the part of the agency. So this kind of leaves it again, I think, to local and state entities to incorporate nicotine products of any type or source into their tobacco control regulations, and retail licensing could be a first step towards curtailing the presence of these products while the FDA sorts out how they want to regulate non-tobacco derived nicotine. There are also some creative local efforts to use federal legal requirements in novel ways. For example, the LA City Attorney has successfully brought claims against the e-cigarette company, against e-cigarette companies under California's unfair competition law, arguing, among other things, that selling products without having gone through pre-market review constitutes an unlawful business practice. The LA City Attorney announced earlier this year that it announced a $1.2 million penalty and an injunction against the company Candy Pens, Inc., preventing it from targeting to youth in its marketing campaigns. The California unfair competition law empowers the Attorney General, district attorneys, and some city attorneys to enforce that law. And using the warning letters to companies that Neil highlighted earlier could be a good place to start. So to bring this all back to what opportunities local and state actors have to address some of the problems with pre-market review we've talked about throughout this presentation, let's discuss some potential solutions. So first, stronger local laws could include affirmative language that products that have received marketing denial orders may not be sold, even in jurisdictions that do not have TRLs. So what this would effectively do is give the locality authority to enforce federal law and then provide another avenue to ensure unlawful products come off the shelves. Going further, local and state laws could also give local enforcement agencies authority to enforce any federal requirements that apply to tobacco products. And then for those jurisdictions that have TRLs, tobacco retail licenses could also explicitly prohibit the sale of products that have not received affirmative marketing orders from the FDA, as is the case in San Francisco, Livermore, Richmond, and then the other jurisdictions we mentioned earlier. And then, of course, localities can go further than what federal law requires by prohibiting the sale of all flavored products, regardless of whether they receive any marketing authorization from the FDA. Although the FDA has indicated it plans to prohibit the sale of menthol cigarettes and eventually act on flavored cigars, and it hasn't yet authorized the sale of any flavored e-cigarettes other than tobacco flavor, these types of comprehensive restrictions at the local level could be enacted much more quickly. Localities can act more quickly than the federal government. And it would ensure that no products such as hookah are left behind. And then lastly, as we mentioned before, localities can go beyond flavored restrictions and simply restrict the sale of all commercial tobacco and nicotine products in their jurisdiction. So with that, here's our contact information. We're happy to take follow-up questions if you have them after you kind of digest this information, but we do have a lot of questions right now. So I think we'll start with the ones that we have.
I'll jump in real quick just to clarify, and I appreciate that people noted this, a bit of a slippery tongue of mine. The flavored blue mint, green mint, Verve products were approved. Vuse Solo was approved for tobacco, the original flavor, which is tobacco flavor, and their G1 and G2 cartridges. The menthol flavored Vuse cartridges are still, we still don't know. We don't know if that's, well, I have not yet seen FDA approve or deny that. So thank you to the robust chat and the questions on that. And I apologize for being a little too excited in sharing this information.
Yeah, so I think we let's see. Yeah, so there is one good question about preemption here. I think hopefully we touched a little bit on the, FDA does not have the authority under the Tobacco Control Act to regulate non-tobacco derived nicotine products. They do under their Drug and Device Authority. So it's not that they don't have any authority, but all we know so far is that they've sent a warning letter, and it's really hard, as folks have learned, to get a good sense of what's going on. I think sort of not commenting on and not responding to issues and pertaining to ongoing investigations is actually a pretty standard response, and it's really frustrating. I totally understand that. There is a question about preemption and how preemption might complicate the idea that localities not follow federal regulations. So localities can go further than the federal regulations. There is an explicit savings clause in the Tobacco Control Act. There's an explicit preemption clause, but there's explicit savings clause in the Tobacco Control Act. There's an exemption to the preemption clause. So anything that has to do with the sale of products as opposed to, setting standards or manufacturing is not preempted. There is ongoing litigation about, what that means and whether or not flavored restrictions are indeed sales restrictions or whether they are tobacco product standards. And as many of you know, LA County was sued. That was actually argued on appeal in the Ninth Circuit a couple of weeks ago. There's an ongoing case in Minnesota in the Eighth Circuit. San Diego was also sued, but the industry is going to challenge any of these restrictions, regardless of whether it has any basis in the law. And as courts have ruled unanimously in, I think, like 11 cases now, that these sales restrictions are not preempted and they're explicitly protected by the localities are able under the Tobacco Control Act to enact sales restrictions. Any sales limitations really should be within the authority of the local or state government to enact. Let's see. So, yeah, someone did want clarification, I guess, Neil, again, on what was approved. And maybe we should go, and actually, I'm sorry, I shouldn't even say the word approved. We're really careful when we're talking about these. They're authorized for sale. They are not approved. Maybe it's semantic.
They're not approved to, they're not like approved to like, oh, this is going to be a healthy thing. It's not that. They've gone through the process for PMTA. They have marketing granted orders. They're still very much operating under other limitations for marketing and labeling.
Mm-hmm. And I think that this is a distinction that folks also asked in some questions that we received earlier. There are a lot of jurisdictions that have language in their laws that restrict the sale of certain products, and they exempt products that are approved as cessation devices or as nicotine replacement therapies. Those are very different than these products. They would not receive authorization for sale from the Center for Tobacco Products under this process. It's a different process. These products that are receiving marketing authorization under the PMTA process are not being approved as cessation devices. They are not being approved as NRTs. And so they will not fall within any kind of exception for products that have proven that they can actually be used as cessation devices. So the other, Neil, feel free to jump in if you want to answer other questions as we're seeing them. Yeah, so the guidelines about what qualifies as appropriate for the protection of the public health. Yeah, there are no regulations that spell out how those three prongs that we outlined a couple times should be applied. So the only guidelines we have are the ones that are in the statute, and they say, you know, that agency can basically determine whether the sale of a certain product is appropriate for the protection of the public health, or it also applies in other contexts, but we're just talking about product authorizations right now. But they have to take into account the risks and benefits to the population as a whole, including the increased, you know, likelihood of initiation amongst those who don't use tobacco products, and then the increased or decreased likelihood of cessation by people who do use tobacco products. So those are the three elements that we know that the agency has to consider. But in terms of how those standards are applied across the board and in the context of different product authorizations, there are no guidelines. Let's see.
That's a great, are we noticing that synthetic nicotine products are on the rise as a result of the FDA loophole? I caution because I'm not super familiar with enough of the data to indicate rise in any precipitous manner. What we have seen is that Puff Bar is very popular among minors, minors under the age of 21. And Puff Bar has made a claim to their fame as being derived from synthetic nicotine. In at least in one instance, even boldly flouting the FDA with a statement that says designed to get around FDA, is really bold, get around FDA regulation. And so I would be I would not be surprised if we see synthetic nicotine products very quickly entering the market, since this is currently a bit of a regulatory blind spot. Whether it's alternative nicotine products that are not captured under current tobacco control ordinances, or things like puff bars, chews, dissolvables, any other number of sources for getting a nicotine fix that is not derived from a tobacco plant.
And then a question about, are there regulatory guidelines regarding a company's advertising an approved MRT on the same website as products that have not received an authorization through the PMTA process? It's specific to Lucy. So I've heard about Lucy. They do have an approval, an actual approval for sale of their specific lozenge as an NRT. And as this person notes, it is very confusing because it's sold under the same name as products that do not have authorization for sale as NRTs. You know, because they're also advertising themselves as non-tobacco derived nicotine, they haven't applied for, as far as we know, applications for sale under the PMTA process. I mean, they may have, we wouldn't know because we don't have information about who submitted what applications, unless the products are already on the market. So it's a little confusing. I suppose we could figure out if they submitted an application, but I don't believe that they have. So anyway, no, there are no guidelines about that. And I heard on a call yesterday that I think this is the first example of products being sold under the same exact brand name for NRTs and non-NRTs. And so that might be something, we would hope that there would be some crackdown on that. But obviously, we're just seeing really no ability to follow up on a lot of these. And, beyond sending the warning letters that Neil talked about, there isn't any effort to do anything beyond that. So let's see. How is synthetic nicotine different than tobacco-derived nicotine? We're actually going to be having, I believe, a webinar on synthetic nicotine in December. Is that right, Neil?
Yep. Me and Natalie. We're going to answer that question, anonymous attendee. And hopefully everyone else on the call and many more, because this is a really important one. And Meredith Berkman from PAVE just linked an important update that this is an issue that is gaining some traction even within the political spheres, which is always nice. On a disclaimer, I took one class of chemistry in undergrad many years ago. So not a toxicologist or a biologist or anyone who would have a deep understanding of this. From a regulatory perspective, synthetic nicotine is a blind spot in a lot of statutes at the federal level and at local and state levels as well. In a pharmacological sense, they function, tobacco-derived nicotine and synthetic nicotine function in the body very similarly, is my understanding. There are different types of nicotine. And so whether or not synthetic nicotine falls into a different subtype of nicotine overall from what we would get from, say, tobacco leaf or any of the other nightshades, tomatoes and eggplants and whatnot. I actually don't have an answer for you yet. Hopefully we do in a couple weeks. And if we don't then too, then that's an important question to really start kicking over to researchers. And I know some of you and some of the colleagues in the research space are looking into this. And hopefully we'll have answers that can inform policy soon. Sorry to give you a dodge of an answer there, anonymous attendee, but I wanted to be truthful.
So yeah, I mean, I think the questions about kind of like the synthetic nicotine regulatory confusion and overlap, and I think that's probably better answered in the webinar about synthetic nicotine. I don't want to speak out of turn here. No, we're happy to have you, Meredith.
And Meredith, we welcome you really driving up, because you're asking the questions that everyone else is thinking of. So
yeah, they're incredibly complicated questions.
Yes.
Yeah, I mean, I think that's a good point that there are certain companies that are perhaps advertising themselves as tobacco-free nicotine. They're still applying through the PMTA process, and I don't know. That at least I suppose was a choice on the part of the company. It's hard to know, but yeah, I think sort of any other questions about the PMTA process, we're happy to answer. And this webinar will be recorded, as Stephanie, or have been recorded, as Stephanie mentioned at the beginning, and she'll send around a link. We would really appreciate filling out the survey, but if there are no more questions, we will wrap it up. And thank you all so much for attending.